Okay, well I think I'm first on the heading there, so I'll start first. As you'll be able to tell by process of elimination, I'm Julia Belyavin. I'm a family practitioner based at St John's Chambers in Bristol. I did pupillage there 15 years ago and liked it enough that I've stayed for the 14 which have followed. I'm also deputy head of pupillage, and so I'm here today with both of those hats on. And if you do want to come and chat at the Chambers stand afterwards, then please do. Now we've got some wee bullet points here that they want us to talk to you about. The first one is why we chose the bar, and in particular why we chose the relevant area of practice. In terms of why I chose the bar, it probably makes my toes curl now, but I think I chose it because I liked the idea of getting paid to argue. I didn't realise that I would actually, as a family barrister, spend a lot of my time trying to talk my clients out of arguing. Whether they like that advice or not is an entirely separate question, but getting them to understand, particularly when they're dealing with their children, that particularly when their child is very young, they've got another 15 or 16 years ahead of them, and they can either spend it arguing or they can try and find a way of spending it being a bit more reasonable to each other, isn't something that your law degree or even the BPTC, in my day it was the BVC, prepares you for. In terms of why I chose family law, I suppose two main reasons. First of all, I had very much enjoyed studying it academically, both family law itself, but also land law. But secondly, I think I quite liked the idea of an area of law where you at least had a sense that some days you were helping people. Again, the extent to which that really pans out in practice varies wildly from day to day, week to week, and month to month. But yes, the fact that you're helping people, and then the human element, well, you either love it or you loathe it. If you talk to my Chancery commercial colleagues, they recoil in horror at the thought of having to sit there holding their client's hands while their client is crying. But to other people, the fact that you're trying to help someone through that incredibly difficult time in their lives is actually very emotionally rewarding. In terms of the types of cases that barristers in this area deal with, well, there are two main practice areas within family law. There are children cases and there are money cases, and then there are subdivisions within those. So perhaps dealing with money first, there's financial remedy work when a marriage is broken down, or there's property work where a cohabitative relationship has broken down. And then there's also Inheritance Act work, and I know that some of you with an eye on Chancery Commercial will be whispering, but that's really Chancery work. Well, it's a bit of a crossover area, to be honest with you. And so those are the three main areas of financial work. And then in the children sphere, there are probably again three main areas: public law, private law, and court of protection work. The latter only applying to older children. Majority of children work will be either public law, so care proceedings where the state is applying to ask that the court considers whether children should be removed from their parents' care, or private law, which is what mostly turns up on the telly, couples arguing about various aspects of their children's care post-separation. And I suppose in that regard I should just point out that it never ceases to amaze you as a practitioner quite what they can find to fall out about, although most of the time it's the predictable who does the child live with and how often do they spend time with the other parent. It can be everything from what school do they go to, can they go on a particular school trip, and even things as unedifying as quite which supermarket car park are you going to meet up in to hand the children over in. And again, at times, being very frank, it can be hard to bear in mind that you went to law school to focus on the merits of Waitrose versus Aldi. But all humour aside, these things often matter a lot to your clients. And so, although to you it seems fairly trivial, it's your job to get the result that your client wants. What do you find appealing about this area of practice? I think I've really touched on that in why I chose the relevant area of practice, but also I think what I like about it is that although the general outline of each case is relatively familiar, the facts are always very different, the personalities involved are always very different, and that is what, after 14 years, still keeps me coming back into chambers most weeks with a smile on my face and a bounce in my step. The next one, I'm afraid we've already at the table here exchanged a wry smile about what the lifestyle implications of this area of practice are. Family law is a very court-based area of practice. Certainly, I'm predominantly a public law specialist these days, and anything which is very court-based means that you have very fixed deadlines over which you have only limited control, because you can ask your clerks to get the papers in for 24, 48, 72 hours, however optimistic you're feeling, and your solicitor can even do their very best to get them in, but they are also reliant on other people meeting deadlines and filing documents on time, and this doesn't always happen. And sometimes you will be doing emergency hearings, particularly in the child protection sphere. You may be sat in court thinking you've got, in chambers rather, thinking you've got a nice quiet day, you were going to catch up on some admin, your to-do list is shortening nicely, and then a call comes in, there's an emergency protection order, I don't know which particular court, and so out of the jeans, into the suit, off you go, and your day has suddenly turned upside down. So there can be early starts, late nights, disrupted plans. You certainly need friends and or partner who are understanding of the fact that your life will not be entirely predictable. But the other lifestyle implications is that you'll be doing something in which is varied, exciting and challenging, and which most days is therefore, if not exactly enjoyable, because you're dealing with people sometimes who are at rock bottom, and sometimes all that you can do is offer emotional support to your client after the worst thing that they can contemplate happening has happened to them. But that is not enjoyable. If you get a kick out of that, then you've got some personality aspects which might need considering. But it has its own level of emotional reward. Key skills and personal qualities, I think, are needed to succeed in this area, and any personal qualities that would make it very hard to succeed. You need good people skills. You need to be able to build a rapport with your client quickly, and you need to be able to get your client to trust you and to feel that they should listen to your advice. And quite often, given the limits of public funding, you will meet your client for the first time either a couple of days before a final hearing or on the day of the final hearing, because there just aren't the endless public funds for you to have endless conferences with your clients. So you need to be able to build that rapport up, but you also need to have objectivity in spades, because the minute that you let yourself get too emotionally engaged in a case and too sure that your client is right, you have failed your client. If your client just needed a yes man who was there, or woman, who was there to nod obediently and say, I believe in you, I will fight for what you want, regardless, they might as well have just brought their mum, their dad, or their best friend. They need someone who can step back and say, okay, that's what you want to achieve, let's look at the evidence, let's look at the law, let's see if I think we can achieve that. And if it's a factual dispute, you might be saying that X, Y, and Z happened, but I have to be honest with you, looking at the evidence is stronger that A, B and C happened. Now don't worry, if you want me to argue in court that X, Y and Z happened, I will argue that X, Y and Z happened, but you have to be aware the judge may find that A, B or C happened. And those are difficult conversations to have with your client, particularly if you've only just met them. And so those skills are very important. And I suppose the flip side of that, any personal qualities that will make it very hard to succeed. Again, we've had a little bit of a wry laugh about this already. Certainly, if you like routine, if you like your day to be nicely organised, then frankly you probably shouldn't be a barrister at all. You certainly shouldn't be a barrister in a very court-heavy area of law. But also, if you're someone who either gets too emotionally involved in a situation or is so lacking in empathy that you can't see how your client might feel about something, when you're giving them bad news, then it's an area that you will struggle with. You need to have logic, you need to have good analytical skills, but you also need empathy and the ability to tell people the logical outcome of what is facing them in a way that they can understand and come to terms with. So I think that's more than my 10 minutes taken up, although we're probably padding just a fraction because, we're not a man down, it's okay. So I will
Sorry, everyone.
hand over down the line.
Hi, my name's Adam Taylor. I'm a barrister at Crown Office Chambers in London. I have been a tenant for 2 years now. I did my pupillage at Crown Office Chambers. I practice in the areas of personal injury, commercial, property damage and professional negligence, and also a bit of insurance work. I chose the bar after making all sorts of quite random applications to all sorts of quite random companies, which my friends still laugh at me for, because I wanted to do something that was intellectual, something that was challenging and stimulating, would have me thinking every day. But I also wanted to do something that was a bit more active, a bit more performative, a bit more exciting. So in my personal injury practice, I'm in court a lot. And that's basically what I came to the bar for, was to be able to use my brain and stand up and sort of have almost a hybrid between, sort of doing something academic and doing something, theatrical almost. And that's worked out very well. The types of cases that I deal with, because at Crown Office we have a number of areas of practice, when you're junior you have the chance to sort of have a more varied practice. And what you find is that as you get older, quite organically I think, you start narrowing down and you start focusing in on one or two areas, because nobody can be a specialist in everything. So at the moment I work across those four areas. And there's a real difference between, for example, the personal injury side of my practice and the more commercial side of my practice with the professional negligence. For example, if you do personal injury, you will be in court all of the time. You will be doing trials all of the time. And when you start off, they might be quite low value trials, but you will be in front of judges, you will be cross-examining witnesses, and you basically will be doing what I came to the bar to do. I think that's very true of criminal family practice as well. On my commercial side, and I think the balance is really good at the moment because it's much more advisory, it's much more drafting, cases are bigger, they take more time. There's more, for example, conferences with clients. So things move a bit slower, you're not in court as much. But certainly in my practice, there's a nice balance between going to trial, asking questions, standing up, putting arguments forwards, and working in chambers and sort of thinking through a case, drafting submissions, that sort of thing. The types of work involved in personal injury, for example, I deal with fraudulent cases or potentially fraudulent cases where we have to test the evidence and decide whether we want to run a fraud defence. And there's ethical issues there. I'm sure you'll all know who are doing the bar course. I deal with lots of, I do work mainly for defendants, so that's usually employers, companies, and so I meet a lot of people working at companies. Maybe there's been a claim brought by an employee, and so aside from the legal issues, there's a sort of political angle to it. On the commercial and professional negligence side, I deal with claims for and against solicitors. There are cases with insurance brokers, and on the commercial side I do sort of property damage, sale of goods. So basically my practice is contract and it's tort across a wide variety of sort of industries. The lifestyle implications, I think, depend on what work I'm doing. Like I said, if I'm doing personal injury, I'm in court every day. I'm all over the country because the clients will be potentially national with different branches, and we basically work with them and with their insurance companies. So I might be on the 6 o'clock train up to Newcastle to do a trial, and then you win, you lose, you come back down and you have to think about what am I doing the next day. So it's very sort of last minute in the sense that you have to be able to move directly onto something else. So you have to be sort of able to recharge and go again. When I'm doing my sort of more commercial practice, I'm in chambers doing papers. So you have to think, when you're thinking about the area of law that you want to do as a barrister, do I want to be somebody who's in court every day, who's travelling up and down the country, who has quite a chaotic lifestyle? I think, I would accept that. And I think my friends would tell me that. Or do you want to be somebody who is, in chambers at 8 o'clock, leaves at 6, does your papers, goes to court once in a while? Because, they're two very different lifestyles, and it's important to think about that at the start. I think also, people, they come to the bar because, they love the idea of it, they love the law, etc. But I think you also have to think practically, financially. When you look into different areas of law, there are lots of different ways in which you would be paid. For example, in personal injury, defendant work is insurer-backed, so you know that you're getting paid for everything you do. If you do claimant personal injury work, you will probably be on what we call a CFA, and a no-win, no-fee. And so you may do a load of work in a case, and if it doesn't come off, you might not get paid. So there are different considerations to think about when you're choosing the area of law financially as well. Key skills and personal qualities, I think most of all, you have to be precise, you have to be accurate. When you're doing a written advice, the client isn't going to want to sit there and read 20 pages of waffle. They're going to want to know what the answer is, how likely we are to win, and what we should do about it. So, you haven't got time, in a busy practice, to not be precise. When you go in front of a judge, they're going to want to know, what are the key issues? What are you saying about them? If you start being unclear, you're going to get punished for it. I think secondly, and this is especially true more at the junior end perhaps, but you have to be confident, because there will be a time when you do something new for the first time and you won't feel confident about it. It might be your first court appearance, it might be your first settlement negotiation, it might be your first advice, but you have to be confident in what you do, because people are expecting that you will know best, and you have to project an image that you do know best. So it's important to have that sort of inner strength, I think, to be able to convince everybody else that your advice is to be followed. I think you also have to be flexible, finally, because as I said, this isn't a 9-to-5 career, and so your plans will change at the last minute. Instructions might come in late. You might have a 1-week trial which settles, and then suddenly your diary's empty. So you have to be able to, I think, live a slightly chaotic lifestyle, but the benefits are there if you think that's for you. So that's my piece.
Hello all, sorry for being late. I was told 1:40 by my clerk, so the first thing you need to do being a barrister is have someone else to blame. So I have that in the bag. But there you go, the blame's in the corner. I'll just run through the questions, picking out the ones I find most interesting. I've heard what you've been told so far and agree with everything that's been said already, so there's no point in repeating that. But firstly, why choose the bar? Why choose my area of practice? Well, I think it's, for me, just quite useful to step back to what I was doing before the bar, because I did a chemistry degree at university, and during my sixth form, I always thought, well, maybe I'll go into law at the end of university time, but I was really into science, really keen on doing that at university. Got to the end of my science degree, as many people do at the end of their degrees, and think, what the heck am I going to do in my life now? And like was being said earlier, you end up applying for lots of different jobs. I was really keen on doing intellectual property law, and I applied to become a patent attorney, actually in some offices just down the road here. And I was on that career path, thinking that's what I wanted to do. And then there was just a moment where I stepped back and thought, hang on a minute, do I want to become a patent attorney working within kind of the solicitor firm framework, or do I really want to be a lawyer leading a case in court, the one that people are turning to asking for advice? And it was at that moment that I thought, hang on, that is what I want to do. You then have the realisation of the cost it is to train to become a barrister. And at that point, I had to contact the Inns of Courts and seek scholarship, sponsorships and the like. So you're all here, and many of you probably already have scholarships, already thought about that avenue. But certainly my first advice to anyone trying to get to the bar is think about where you can get funding, because it is so expensive. It was expensive for me 10 years ago, or 9 years ago. It now is even more expensive to get through the bar course. Having then gone to the bar, done my conversion course, then the bar course, then I was thinking, right, I'm going to do intellectual property law and become a real intellectual property law geek. During the year of applying for pupillages, I happened to go to Blackstone Chambers for a mini pupillage and fell in love with the set. Now, everyone falls in love with different sets because it depends what kind of person you are, and all sets are very, very different. But for me, Blackstone Chambers was a perfect fit. And that kind of leads me to the second point I'd say is when applying for pupillages, really take the time to learn about the set, because every single set has a different ethos. It's a horrible word to use, but it's true. Every set has a different ethos. Obviously, every set does different work. The best way to learn about a set is to go there and do a mini pupillage. You learn from the experience, but you also show the set that you are keen on them and you are taking time out of all of our busy lives to go into that set and to experience it. Briefly on mini pupillages, I had some really horrible experiences. I had some really great experiences. This is what happens. There were some occasions where I would go to the set, I'd go to reception, a clerk would come out and say, blah, blah, blah is going to come and see you in a few minutes, and I would spend 4 hours sat in reception waiting for blah, blah, blah to come and see me. These things happen. Safe to say I wasn't that impressed with that set, and I didn't necessarily apply to that set afterwards. But if any of you experience that kind of thing within Chambers, don't be surprised, be aware that it happens to all of us. And there are other sets who run really great mini pupillage schemes. So at Blackstone Chambers, why did I fall in love with it? Well, I loved the breadth of work that goes on there. So I specialise in financial services law. With my science background, I like the geekery of the financial markets. But I also do public law. I act for the government in various cases. I act against the government in various cases. I do human rights law. Outside of work, I'm a keen sportsman. So every now and again, I do a sports law case just so I can marry together my hobbies and my work. So, for example, I've got a case at the moment involving cycling. I've had cases involving Formula One racing. And again, by having a broader practice, you're able to get in those different areas of law. And one thing to remember with things like sports law, media law and the like, they sound very sexy, but ultimately they are contract law, they're tort law, they're all the same issues of law that arise, but in a slightly sexy industry. So don't be scared off by those areas of practice. Equally, I wouldn't necessarily say at your level you should be saying, right, I only want to do things like media law, sports law. Those are things that you can find in your practice as you progress through the years. Okay, lifestyle implications I wanted to touch upon, because I possibly came into the bar without fully appreciating the impact it would have on my lifestyle. I think it's certainly being a barrister is a profession. It becomes more than a profession. It does become your life. You have many clients who need to speak to you immediately, and whether or not you are skiing up a mountain or on holiday in some Caribbean island, I don't know, they will want to speak to you. And ultimately, if you want to succeed in your practice, then you will have to pick up the phone to them and you'll have to speak to them. And I think you have to be the kind of person who doesn't see that as a chore, but actually is quite excited by all their cases and is quite pleased to be speaking to their clients and find out what is going on in your cases. So being a barrister does have severe lifestyle implications. If you're looking for a 9-to-5 job, then being a barrister is not the job for you. It then has implications for your friends, because your friends come to realise that you're just a flake Monday to Friday, you'll hardly ever see them, You'll have plans to meet them at, I don't know, the cinema at 7 o'clock, and at 5 minutes to 7 you'll text saying the clerks have just given me a new case, or I've just had some urgent matter coming up and I can't come. You lose some friends very quickly, you gain a lovely set of friends at Chambers, but those who really care and stick with you do stick with you. And that leads me then finally to key skills and personal qualities. One personal quality, I think, is an eye to detail and almost a wish to be perfect at your cases. You have to really love your cases, focus on your cases, and try to do the best at all times on your cases. But the flip side of that is you have to grow a thick skin, because you will have some torrid times with your cases where you've told a client, I really think we're going to do well here, because that's what you believe. And then you go to court and you realise you weren't just not going to do well. You were going to be slammed by costs, you're going to lose badly, but these things happen. These things happen to all of us. You have to give the advice to the client, tell the client this is what's happened, explain the consequences, but then ultimately the client will shake your hand and walk off, and you are then left on your own. And often, because you get so personally attached to cases, because you love them so much, because they become your baby, you then go through this bizarre mourning process afterwards. Now, what you have to learn very quickly is that thick skin, that you walk away from your case and you say, right, I've learnt a lot, I'm going to take what I've learnt to other cases, but ultimately tomorrow's a new day with new challenges and new things to face me. Now, what I like about my chambers, and I'm sure other chambers are the same, is we very much have an open door policy. We also share with colleagues. So there are times when I've come back from the court and I've turned to my friends and said, you will not believe what happened to me today. And then you hope that they come back and say, oh, well, you won't believe what happened to me last week. And then you have a Schadenfreude type conversation, both of you enjoying the fact that you've had crap days, and you move on with things. So I think that is a key skill. And to be honest, I'm however many years in practice I am, 8-9 years, I don't think I have that thick skin even now. There are still times when I go home and I feel mightily depressed about what has happened that day. But slowly it's something that I'm acquiring. So I think if you're someone who's really, really emotional, knowing that from the outset, you have got to think very carefully about this practice. But provided you're not that person, it is a skill that you can learn as you're going along. Finally, one other thing I should say that I love about our job. Each of our cases, you have to become the expert of that field. So I will have cases where I'm cross-examining an expert of some certain transaction that happened in the city. Now, in that cross-examination, we're essentially having an argument. And Barristers is in such a wonderful position because you get this right to have an argument with someone where someone has to respond to your questions. They can't just skate around it and do a politician's answer and not answer, because they'll get a judge on their back saying, you heard the question, answer the question. So it's a real great privilege we have. But to have that argument, you have to learn cases so carefully. But that comes with the joy of learning a field, learning an industry, learning how to argue with this expert who's the top of his game. You've got to be at the top of your game in that field as well. And that is a real privilege. Now, once the case is over, you walk out the door, and it's so funny how things fall out of your mind, and you've gone from being the expert of the field all of a sudden to can't remembering it at all. It's a bit like being, I suppose, back at school when you were revising for exams. You prep for your history exam, you know every single date that coincided in the 20th century and the Second World War, then you walk out of the exam and you can't remember any date at all. So it's very similar to that in preparation style, but it's a real privilege to have a job where you are learning every day about new industries, new cases. Now, sorry for rattling through, but I'm conscious it's 2 o'clock and there may be some questions if there's time.
Yeah, we've actually got a little bit of time for questions. I just wanted to say that this is actually quite a good opportunity because we have got different types of practice here. I think Julia said she's doing family law, Adam does more personal injury, and Simon is doing a lot more commercial law. If you want to get a kind of feel for what life is like at the bar, or you're trying to make a decision about where you want to go for mini pupillage, this is a really good time to ask questions. I'll open it up, just stick your hands up and go for it.
Far away.
How many mini pupillages would you say someone does on average for a
I mean, I read pupillage applications. It's anything between 2 and 2, 3 to sort of 10, 15. To be honest, I would say once you've been to between 2 and 4 different types of set, you should have a pretty good idea. And let's be realistic, particularly with the financial pressures that you've got coming up ahead of you, it's perfectly understandable if you want to be able to do a summer job and not spend your entire summer doing what are still generally, and it is a failing of the bar, unpaid mini pupillages. So yeah, my personal view, 2, 3, 4 is enough, and don't get sucked into doing 10 or 15. But
Yeah,
others may differ.
I think if you're doing 10, somebody's going to look at the form and say, why have they done that? You know, that seems like they don't know what they want, and like they've got too much time on their hands, to be frank. I think, you know, that would arguably be a real negative. I think also, you know, you don't want to apply to somewhere that you haven't done a mini pupillage, you know, in that general area, because again, somebody will look at the form and say, do they really want to do this area of work? Do they really want to come to our chambers? They haven't done a mini, like how do they know anything about it? So I'd say those are probably the 2 tips.
I think that's right. Because I started from an area that was so far removed from law, I did a few mini pupillages when I was still at the end of my chemistry degree on my 4th year, doing more run-of-the-mill sets. So where I was at university, I went to sets near there, doing a bit of common law just to understand what a barrister did, because I had no clue really, other than what you see on TV. Then once I came to London, I was a lot more focused, because there is a real limit on how many you can do. But I remain of the view that those sets that you really want to go to, you should try to put the effort in to show that you're interested. Now, if you can't go there for a long mini pupillage, and they're a set that's willing, why don't you write them and just say, I'm interested in this set, is there someone I can speak to at the set, or something along those lines. A lot of sets now have assessed mini pupillages, so you don't really have a choice. If you want to go to that set, mine is an example, you have to go there and have the assessed mini pupillage phase. So be targeted, and I suppose the number depends on where you're coming from, because I probably admit I'm towards the 8 to 10 range that I did, but I probably did too many. But it was a learning curve, and as the years went on, I focused more as to where I wanted to go.
Any more questions?
Yeah, maybe the guy in front first, and then the guy behind.
So, taking the date as we are now, and obviously pupillage applications opening up in January, what can anybody in this room do who's studying full-time between today and that deadline to improve their chances of getting pupillage?
I think the main thing that you can do best would probably just be to make sure that you've done your homework, so that when you're filling in the part of your application, whether it's a gateway set or a non-gateway set, which specifies why you're interested in that chambers, if you haven't done a mini pupillage there, that you're able to make it genuinely targeted and specific in a meaningful way. Sycophantic phrases just saying how much you've read about St John's or Blackstone or Crown Office and you think they sound lovely. Well, if you're application number 15 that I read and you've written something that bland, I really don't rate your chances, I'm afraid. So you do need to try and make it personalised. But yes, showing that you've done your homework, and frankly also just proofreading your application and getting someone else to proofread it. You've had some advice about the need for precision, and again, we all appreciate that particularly for non-gateway sets, you are having to do a lot of personalised applications, but if it is littered with spelling mistakes, punctuation errors, misplaced apostrophes, the average barrister sifting your application will be very, very underwhelmed. And so take the time to really, really proofread it. And as I say, get someone else to read it, because if you're anything like a normal human being, and I can say this for probably at least 50% of the skeleton arguments I write, I finish it, I press print on 2, 4, 6, however many copies I need for that particular case, and that is when I notice the final error, after I've printed 6 copies.
I agree. I think actually when you read something on a computer, as most of us do these days, it's much easier to miss these little things, and that's why printing it out and double checking it. I think the one thing I didn't realise when I was applying, or I didn't fully appreciate, is that self-employed people have to sit down in their spare time and go through, you know, a large number of application forms. And, you know, it is something that, you know, is you know, it's draining. And a lot of them...
Apologies.
No, not at all, but...
Hey, someone did it for us.
Yeah,
So
exactly. And, you know, a lot of them will have a lot of similar information. You know, everybody will have mooting, everybody will have, you know, mini pupillages, etc. So a lot of them will be quite similar. So, you know, what's really refreshing is, you know, when somebody says in a snappy but sort of not overconfident way, like, I am special, this is why. Because that's what we're really looking for, you know, something that just leaps out of the page.
Yeah, no, I think in preparing for interviews, one good thing to do is, once you've got your perfect application form, and I agree, the aim should be no typos whatsoever in your application form. Send it to anyone you know to get them to proofread. Because there's so many applications that one has in front of some when you're going through them. It's very easy just to start acting like a teacher and getting your green pen out and circling apostrophes in the wrong place. And you don't want that kind of attitude with the person who's reading the form. So definitely get that done and dusted. But then once the application's gone in, just reflect on what you bring to the chambers. You're likely to be a student, so you can't say I'm coming with lots of clients for you. But think about what skills, what assets can you personally bring to the chambers, but also think, if I was looking at my CV, what is missing in the CV? Now, it may be the university you had a bit of a harder time and your degree doesn't fairly reflect what you think it should reflect. So start thinking about those kind of things, thinking, what am I going to say to the chambers in order to address any potential question they may have? And it's hard, all the interviews are different. Also, in preparing for interviews, if you know anyone else, any other friends who are going interviews at the same place, or even if they went interviews the year before, just find out what kind of interviews sets have, because certainly when I did it many years ago, some sets would have ethical questions as the first round of interview, so in order to prepare for them you've got to read the Bar Code of Conduct. Some sets would have more general legal based, where they'd give you a copy of Chitty, the practitioner's text for contract law, and say go away and write an opinion on this. So just try and get as much information from as many different places as you can in order to prepare yourself for the interviews. I think there was another question just behind.
There was the row back, yeah.
I was wondering, how do you stay motivated in terms of keeping up with your workload and dealing with all your clients? It's obviously takes up a lot of time. And in terms of your own, how much free time you get.
It's a really interesting question. It's really interesting. The motivation's a hard one because it kind of ebb and flows through the year. When I've got cases on, like at the moment, I'm always totally motivated towards those cases. But then there does come a point, which often is just before the summer holidays, when you're thinking, God, do I need a break? And then it's really important, and again, it's something you learn over years. I certainly didn't know it when I first started, but it's really important to try and get a window in your diary where, and you prepare early so clients know that you're not around, because as I'm saying, clients may phone you when you're away, you need to pick up the phone. But at the bar, there is this kind of window in the summer where people go away. You often find old QCs will go away for 3 months and they'll never be contactable. Now, juniors can't do that, and that's not how the modern bar works anyway. But just try and get some time away to recharge your batteries, because you really do, because it's mentally draining and emotionally draining, and you need that time to recharge, and then you come back to chambers buzzing and raring to go for your next case.
Yeah, I think, you know, if you get free time, you know, snatch it, because, you know, for example, let's say that you're all prepared for a big trial or something like that, and it settles, and then, you know, your diary's free for a day or two because it's too late for somebody to put something else in. You know, snatch it, take a day off, you know, go and for a jog or whatever, you know. Just, you have to take that free time while you can. I think the other thing is, you are self-employed, you can choose where and when to work. And I think, you know, the benefit of that is, you know, we all work really hard, but we can do that, you know, at our leisure, essentially. You know, if, you know, I've got friends, you know, who, for example, you know, can't get out for dinner because, you know, they work really long hours and they're stuck in the office the entire day. If I want to nip out for dinner, 7 till 8, I can do that. If it means I have to work an hour later before I go to bed, I'll take that hit so I can, keep my sort of social life going, as it were. So you don't get as much flexibility as you think you will have, but you still get more than sort of, somebody working employed.
Yeah, I wouldn't say I've got a huge amount to add to that. At the end of the day, the motivation comes from why you originally go to the job. If you completely stop enjoying it and you're completely burnt out, then I'm not sure that you can find motivation from nowhere. And so it is about pacing yourself, and as has been said, taking advantage of those times when you have a quiet week. I've just had, after 10 weeks of not having any weekends at all, just had a five-day trial collapse this week, which has been absolutely gorgeous, and so that's why I feel fairly relaxed and quite positive about my job. If that 5-day trial had stood up, then I'm not sure what I would have been saying to you about being a barrister today. So
you wouldn't have been here.
No, I'd have probably been at home crying.
One of the good things with our job, and when I started, I used to talk to people who were starting their own professions, and they would have kind of down times in the office where you've got to pretend to be busy, and you've got to try not to look on Facebook or whatever one does when trying to procrastinate. But at the bar, we are self-employed, and if you want to leave the office because you've got nothing to do, you can leave the office. Now, at the back of my mind, there's always a fear, oh my gosh, maybe you won't have another case. You need to, when the clerks pick up the phone and phone you, say we've got a new case, then the answer has to be yes, because that may be the last ever case you're offered. Now again, over time you realise there are plenty of cases out there, and it is absolutely fine to say no to certain cases. And you make your own lifestyle choices. I've got colleagues at work who have taken long sabbaticals at my kind of level of call because they wanted to go travelling around the world, or they've taken maternity leave or paternity leave. Because we're self-employed, we can make lifestyle choices. You've just got to balance them with how you are caring for your clients and making sure your practice continues.
I have to stop it there. I'm really sorry because we've run out of time. But I do recommend you go around and visit the Chambers stands down in the Great Hall. Just thank you very much to our panel for taking the time to do this.